Welcome back. Well, Andem Ndem joins us now. He's the National Coordinator, Akwa-Ibom Political Action Committee, to give his perspective on this tribunal movement to Abuja. Thank you for coming on this morning.
Thank you for having me.
What is wrong with moving the tribunal to Abuja based on security concerns?
Everything is wrong. One, it's clear violation of the law. No tribunal has any discretion as to the venue of its sitting because it is regulated by law. Apart from Section 285 sub 2, which says a tribunal shall be established in each state. Paragraph 19.2 of the first schedule says the venue shall be proximate to where the election was held for accessibility to witnesses and materials. So by literal construction, there is no way Abuja can be said to be more proximate to where election was held in Akwa-Ibom than in Akwa-Ibom. The only window of maneuverability that the tribunal may have is to relocate from one part of Akwa-Ibom to the other if they feel unsafe. If for any reason that there are security concerns, there are two things. Number one, if you feel threatened, what you do is to lodge a report. The authority that guarantees security at the state level is the state government. Question number one, if there was any threat, where was any report made? Police, state security services, state government, whatever. No evidence of any threat whatsoever.
Oh, he spoke about the messages that were sent to him. We didn't see those messages. He spoke about those who had died, and then while the tribunal was constituted, they actually wrote saying, look, based on what they've seen and what they've experienced, they don't think it will be safe for them.
That makes the case for why the tribunal should sit in Uyo. Number one, they had a preconceived state of mind, because I watched them. You said, at what point did they say, at the time the tribunal was constituted? So even before they sat, you said there must be security or insecurity. You had made up your mind because you had a script you are playing out. So even before the tribunal sat, you had configured a phantom insecurity. That's number one. Number two, I am saying this as a practitioner before that tribunal. As a lawyer in practice, I'm representing not less than 5 clients there. I go there regularly. So I'm giving you direct testimony. He does not have that privilege.
Is it true then that the PDP comes up with 30 busloads of supporters?
That is absolutely untrue. It is only a figment of the imagination of my brother that just left here, because there is no way a vehicular movement of 30 buses will not attract security attention. No, it's not possible. 30 buses moving with human beings in that vehicle must definitely attract security attention. Where are you going? For what purpose?
So how many buses went there?
No bus went anywhere. I'm telling you that...
No bus?
No bus.
How did the supporters get there?
Supporters, they have their cars. They can drive to court. They can come with public transportation. There is no organized vehicular movement to move people for the purposes of brigandage. It is not correct.
So you're saying that there are no supporters at the court?
Supporters do not carry labels or ID cards. They may as well have been their supporters. How do you distinguish between APC supporters and PDP supporters when 2 of them are in the court?
Okay, but they are supporters at the court, whether they're supporting APC or PDP.
People come to court to watch proceedings because it is a public outing.
Yes, there's a very thin line between people who are inside the court premises and people who are outside the court premises supporting one candidate or the other. We have been in this country where we've seen people, political parties or supporters of a particular person in a lawsuit being at the court on a constant basis, in some cases cooking and eating right there in front of the court.
Now, what tells you that it is not the supporters of APC? Don't they eat?
My question is, I'm saying that if that is the case, does such a situation exist in Akwa-Ibom State?
It does not exist. What you have is a normal court sitting. Let me not use tribunal. Maybe it is a bit strange to people. Court sitting, both sides have their legal representation. There's a gallery for people to sit, and there's an overflow outside, then there is substantial security. Okay? You don't loiter outside if you don't have any business doing inside. And once you are inside, you are guided by the rules of the courtroom. Okay? So the opportunity to do violence is not there, except a warped mind had planned that immediately this tribunal had been in review for about 3 to 4 weeks, taking cases regularly. Suddenly, there was this strange relocation. I am hearing today for the first time that they relocated based on a petition by the APC. It's breaking news to us because we were wondering. Do you know why?
No, I think he also said that the Court of Appeal had given them that permission, then they moved.
No, there must be a request. You see, the Court of Appeal sets up for all the states. And let me tell you, even in states that had insurgency, tribunals are sitting there. Akwa-Ibom enjoys near maximum security as I speak. In fact, I'll make bold to declare that after the FCT, Akwa-Ibom is the most secured state in Nigeria, based on the crime index and others.
How does this relocation take away the wind off your sail in this particular process?
Now, it gives us the incipient signs of Salami Gate scandal. And that is why we are shouting early enough.
How?
Very interesting. You see, in the case of Salami, it was a mild and seemingly innocuous interference with the tribunal sitting in Sokoto to consider governorship petition, just as in this case that started. Later, the situation was mismanaged. It was moved to Abuja, and then it developed into an inferno that almost consumed the judicial architecture of this country. So when you see a pattern playing out again, it's safer to nip it in the bud for a stitch in time saves 9. My question is, if justice is to be done in accordance to law, the justice to be served in Abuja, is it any different than the justice that would have been served in Rio?
But Ibaro's understanding of that section 2852 says, much as he agrees that yes, it has to be established in the state, but he also says doesn't mean that they have to all sit in the state. After all, if you appeal, they're not going to sit in the state.
I gave you a further ground that ties in the fact that they must sit there. Paragraph 19, sub 2 of the first schedule to the Electoral Act. Or even more pointedly, there has been a judicial decision, a case as far back as 2005. In the case of Ibori versus Ogboru, it happened in Delta State. There's no reinventing the wheel. These things come up again and again. And if you look deeply, you will see a pattern. In the case of Ibori and Ogboru, 2005, it's in part 920 of the Nigerian Weekly Law Report, the tribunal in Delta State relocated to same Abuja at the instance of Ogboru, and the lawyer to Ibori went and filed a motion challenging it there and said, hey, listen, once you leave your state, you have lost jurisdiction. The tribunal said, no, it is an administrative decision that we didn't need to hear from you. So they decided against Ibori's lawyer. He went on appeal to the Court of Appeal that set up the tribunal in the first place. And the Court of Appeal said, hey, listen, go back to Asaba, because you are bound to operate within the geographical presence of where you are to be situated. You can't come to Abuja and say that you are working for Delta State. So on the basis of that decision, the law is supposed to be in the breast of judges. That decision stands till today. Court of Appeal that sets up tribunal is aware of that. So how can they give a conflicting directive that violates not only the Constitution, but a judicial authority?
But it's not only Akwa-Ibom State that has relocated to Abuja.
The fact that a man decides to sleep over his right does not make the other man unable to activate his own. So we are saying that we smell a rat. It portends an ominous future. We have gone through this route before. In 2011, Akwa-Ibom experienced a very serious situation, and we don't want a repeat of that. I am saying that these are the incipient signs of yet another Salami Gate scandal. It must be nipped in the bud, except there is more to it that meets the eye. They have to tell us why justice in Uyo is going to be different from justice in Abuja.